Hi, everyone. Very good afternoon uh, to this special edition of our in-house counsel forum webinar on corporate litigation policy. Firstly, let me begin by welcoming you all and thanking for taking the time out to be with us today. And this is our sixth in-house counsel program. I'm Prasenjit Chakravarti. I'm a corporate M&A partner in our Khetan's corporate and M&A group. I would like to extend a very warm welcome to each one of you, whether you are in our audience in India or around the world. If you go to the next slide, slide three, let me go. Okay. Yeah. So In-house Counsel Forum is a new program from Khetan this year, following the great success of the firm's virtual M&A program over the last couple of years. In-house Counsel Forum is designed to be a private educational program and discussion forum tailored for in-house counsel teams in India. That's why you've got this invite. The program is structured to provide bespoke professional training and education, not only in substantive law, which is of course very important, but also in management and other topics of interest to in-house counsel. The forum is private in the sense that participation is by invitation only and not open to the public at large. We issue invitations by emails, as some of you would have got, to general counsel, chief legal officers, and senior in-house counsels in clients and close associates of the firm. And those invitations are extended to not only those individuals, but also members of the respective teams. We hope throughout this process to provide continuous legal training and education to in-house teams on matter of great interest to them and their companies. Let me go to the agenda slide now. Now, as you can see that on this slide is today's agenda for the webinar. In short, the format will be a discussion with our expert panel members, including a Q&A session with audience questions. So please, watch this carefully, and as and when any questions pop up in your mind, please post them, drop, and we will take them up. We hope the session will be interactive and invite you to ask questions. As I said, we have already received a fair number of questions in run up to this webinar. But if you, as I said, if you have any questions, do submit it using the portal facility. If we cannot cover all the questions, we will surely respond to you after the webinar by email and get back to you. Also, we will prepare a summary note of the discussions of this webinar, encapsulating the key points, and send it across as well. Now, let me introduce the topic in brief before I introduce our esteemed panelists. I think while doing business, organizations will inevitably face instances where they have to deal with disputes, pre-dispute scenarios, litigations, contentious aspects with third parties, including private parties and government parties. And therefore, it's kind of inevitable that you will be confronted with those situations. And it is therefore very pertinent for organizations to have a very comprehensive and robust corporate litigation policy in place, which acts as a guideline, a guiding tool for organizations on how to manage disputes and litigations. In this session, we hope to discuss and reflect on a variety of considerations and benefits associated with having a corporate litigation policy, and what it really takes to craft a policy. What's the mindset? How do you implement it? What are the challenges while implementing a policy? What should be kept in mind? The key tenets of a corporate litigation policy. All of this we will try and cover in this slightly extended session today. And to talk about all this, I'm delighted to have a wonderful panel here, which I will now introduce. Every person, by the way, who has registered for this webinar should have received an email with credentials of the experts of our esteemed panelists. So I will not spend much time in repeating or summarizing their expertise and credentials. Suffice to say that they have tremendous expertise in in-house litigation experience and have excellent credentials to speak on this topic. So let me, without ado, just first introduce the panel. We have, you can take the slides off now. Sorry, wait. I will just introduce the panel. So on the screen, you can see Dr. Akhil Prasad. He is the Group General Counsel, a board member, and Company Secretary of Boeing India. We have Mr. Deepak Acharya, the Group General Counsel uh, of the Aditya Builder Group and Chief Legal Officer there. Then we have, sorry, this is not moving. Can we go to the next slide? Yeah, so we have Mr. Deepak Chauhan, who is Director and Head of Legal Wellspun Group, and Mr. Rishi Gautam, Global General Counsel of Tata Consumer Products. Next slide, please. And of course, our own in-house champions, law firm partners in litigation field, Mr. Raj Panchmatia and Mr. Kingshuk Banerjee, both seasoned litigation, vastly experienced in arbitration and all kind of litigation one can imagine. And of course, so I think with that, I think let's straight away dive into the discussions. And Praja, you can take off the slides now. Yeah, great. So I think let me first begin by asking a question and throw it to all the four external panelists, because I think it really would connect with all four of you. That does your organization currently have a corporate litigation policy, or have you worked in organizations in the past where such policies were designed? And if so, what in your experience has been the principal objective, purpose, and advantages of having such a policy? So if I may just throw it open, anybody can really, of the four of you, have a go. I must also clarify, I think Akhil is having some technical issues to join, but we are hoping he will join us soon. But maybe Deepak Chauhan, why don't we begin with you? Yeah.
Yes, so incidentally, this happens to be the 10th year of our policy. So we had a policy framed sometime April of 2013, and of course, the need for the policy was felt because we were, very varied in terms of our businesses. At that time we had about 8 or 9 businesses. Today we have about 14 odd businesses. So therefore, with the kind of businesses and as the legal team was growing, the challenges were growing. So therefore, the need was felt that, we needed to have something which was a documented policy around this. The policy, of course, features both litigations as well as potential litigations, disputes. In fact, more used for potential disputes and litigations, let me say that. And Prasenjit, as you rightly said, there is the policy itself starts with an aim and an objective, which I think would be, will be relevant for everybody, and everybody would agree, is that the focus is on how you can work out a solution as early as possible. The outcome is not focused towards, the end result of litigating it. Much rather, the policy itself starts off by saying that, the entire focus is as to how you can quickly resolve the issue, amicably close the issue. Then, of course, it gets into more details of, what is more, as a legal department as to what needs to be done in the policy, and how it interfaces with other businesses and other functions, so to say. Thresholds, values, as to how you will escalate matters, when will you go for board briefings, how will you kind of, summarize things, what, processes you will follow locally, domestically, internationally. So I would stop here for a moment and just leave it for the other panelists. But the policy is encompassing; it covers many areas. But the focus, of course, is that how you work for a solution ultimately, and you work for a amicable way of resolving the dispute.
Excellent. I mean, that's a great starting point, really. I think maybe I go to Deepak Acharya now, I think, to supplement what Mr. Chauhan just said. Yeah.
So thank you, Prasenjit, for having me, first of all. Really appreciate this initiative. I'll echo what Deepak just mentioned, that litigation policy is a key to managing litigations in a large organizations. As we all know, as organizations become more and more complex, more and more large people are involved in the organization, it becomes difficult to navigate a litigation if you don't have a clear-cut understanding of who does what and how we will manage some critical issues. And key thing for me, as I've worked in different organizations, is that initially, when you have a litigation or a dispute, there's a high level of interest from everyone to manage, to litigate, or to resolve. But as time passes, most business leaders will lose interest in litigation, and then it becomes only project to be managed by the team of lawyers. And that's where the dangers of not having a policy lies, because if you don't have a clear-cut policy in terms of how do you manage litigation, then it will fall into one of the lists or one of the metrics that you have, which nobody will really review. As we go through the questions, we will come to one point where every litigation should have an objective, and we'll talk about this a little bit more. But policy helps to manage those aspects in a large organization. In a small startup, perhaps you may not need a litigation policy because you are connected with each other and you are linked up with each other. But as the organization becomes larger, complexities are more, then you must have a policy in place or guideline in place, whatever you call it, a policy or a guidance note. That I think is immensely helpful for everyone.
Yeah, that's again great thoughts to kick things off quickly. I go to Rishi, then I come to Akhil. I think Akhil, as we know, is in Boeing, so he has a different approach to these policies, but of course, from his past experience, he can shed some light. Rishi, why don't you first go and share your 2 cents on this, and before I go to Akhil. You're on mute, Rishi.
Hi, good morning.
Yes.
Am I audible now?
Now you are audible. Please go ahead. Yeah.
Okay. Sorry, so I could not agree less with Deepak and Deepak. I'll be brief here. The two important aspects that this having a policy and adherence to that policy, what it achieves for us is, number one is consistency. So we can immediately respond to evolving situations, whether they are evolving from a regulatory aspect or they are evolving from a commercial sort of a dispute. Whatever be the underlying reason, having a policy ensures consistency. And secondly, I think just echoing what Deepak mentioned, that it's very important to have procedures in place, procedures to initiate the response, procedures to talk about escalation, do's and don'ts. In international geography, again, I echo what Deepak said. Having international presence makes you or mandates you that your policy should take into account difference in the jurisdiction as well. Not each jurisdiction it requires the same approach. So having a policy helps you in making sure that nothing slips through, having a consistent approach, and also mitigation of risk to that extent.
Excellent. I think thanks, Rishi, for those introductory comments. Akhil, if I may come to you now, I will just repeat the question for your benefit. I think since you logged in a bit late, that if your current organization has a litigation policy, I know the answer to that, perhaps not, but yeah, if you in the past have worked in organizations who have had policies, and what in your estimate are the advantages and principal objectives.
So, thank you, Prasenjit. And I think the litigation policy and strategy depends upon the kind of industry you're working in. So, I've been fortunate to work across different industries, starting from Xerox to Electrolux to General Motors to Disney, and Disney to Fidelity, and Fidelity to Boeing. So, moving across white goods, entertainment, media industry versus a mutual fund industry now with Boeing, I think every company has a different appetite for litigation and have a different strategy and a litigation policy. So if I were to talk currently about Boeing, so Boeing has customers, which is Government of India, which is the Ministry of Defense. We have very high profile airline companies who are our customers. So the thumb rule is very, very clear that if you have to sue Government of India, if you have to sue a big customer, which is like Akasha or Air India, the approval for litigation has to come from the very, very top. and it will be very different from if I'm working for a white goods company like an Electrolux, where litigation before a consumer forum or a district forum or a national commission is very, very common. So there, pretty much, you have to defend the interest of the company, and you need to have the decision pretty much lies with the general counsel of the company. Likewise, also for mutual fund, if there are litigations with the Securities Exchange Commission or with SEBI or others, I think it is very clear, that general counsel will take the lead. But the moment you step into a situation where you are manufacturing planes or when you are manufacturing goods of national importance, your stakeholders are very different, and then you have to have a very, very different strategy and a litigation policy. And in the current role, I think it goes right up to the very top. If we have to sue a customer, which is a government customer or a big airline, I think the decision has to come from our global chairman office and the global GC's office in conjunction. So it's not perhaps only the decision of the global GC or the chief legal officer of the enterprise. It has to come with a business decision also. So it depends on where you are. So there cannot be a one size fit all approach.
Absolutely. No, I think that's well put, Akhil. So I think those are really sets up very nicely for now more specific, I think, questions. And I think let me go to the next question. I think this is for Deepak Chauhan, and maybe Rishi, you can supplement it, that we've all now spoken about advantages, potential benefits, success, etc. of having a corporate litigation policy. Now, in your experience, have you witnessed such advantages being realized? Realized being a key operative word here. And perhaps you can provide some examples of what success means in this context. Deepak, maybe you can go first.
Yes. So, you see, let me take up a few examples, to have a very documented and a regimented policy. For example, our policy requires, any litigation which is above a particular threshold, then irrespective, you need to brief the board. Okay. And we recently had a situation where we had to brief the board. And the day we briefed the board, the next day, this information reached the board through other means. So great advantage that, we were actually ahead of time and we were briefing the board even before it actually went through any public medium or through any communication which reached them separately. You see, so different advantages come, and I can think of various examples. Again, if you look at from the perspective of where any litigation has to be handled by at least two individuals from the legal department. Okay. When you look at from a value perspective, it's a documented policy. Now, then you have a situation where one person is available, not available, and you still are able to deal with those situations. So therefore, there are various advantages we've seen of the policy as you continuously kind of implement this. Okay. Ultimately, you're looking for a solution and looking at how you can resolve issues, and you're able to, as Deepak also mentioned earlier, the stakeholders at all levels. Because what we have seen is that businesses tend to move away and drift from, from a role where they are initially very interested to move out and then leave it to legal department to be handling that. So coming to a situation where you want to ultimately settle and come out is where, you need to keep them fully involved. And I see this policy, a documented policy, really helps.
Right. Rishi, you want to supplement that in your stint with Tata's, any situation playing itself out which you kind of can share with us?
Yes, so it's quite important to have a policy and make sure that adherence is equally important. I mean, we came across matters where HR related, and so we employ a particularly large number of employees, and it's a sort of an old company where history. So you can imagine we have matters running from more than 2 to 3 decades, and I'm a little honestly embarrassed to admit that when we review some of those outstanding matters and we evaluate the time and the cost those matters are sort of having the impact on time and cost on us, it made us reconsider as to, are we going on the right path? Um, sometimes you very often don't have an option, and that will never really be part of a policy. You have to be dynamic at that stage. Very often having a policy would have made a lot of difference, where maybe somebody would have or should have sort of said, let us not go down this path, let us not litigate, let us settle, because we do not think there is an early resolution, or the resolution that we want may not be desirable because it deals with the HR aspects. So that is one aspect. The second thing is that I mean, we operate in US and as well as in Europe, but everybody here understands the US lay of land, and all of you have businesses or have worked. So there, it's a slightly different story, and we all understand that litigation, a long winding litigation, very often is not in the best interests of the company. So the policy will require us to have a informed discussion with the stakeholders, whether it is a regulatory matter or whether it is a marketing issue or a trademarks dispute. And our objective would be to weigh the consequences and then decide, are we going to spend valuable time and in US context quite a lot of money to chase this particular matter, or do we settle? And settlement is considered, I mean, it has its pros and cons in the US sort of legal this thing, unlike India. So again, that's a very difficult decision that one needs to take. But those are sort of things where a policy can help you and make it easy for not just for us, even for our stakeholders, for the marketing team to say, hey, look, this is a trademark dispute. We would normally reach a consensus on the basis of this understanding, to try to think of a compromise rather than expecting that the legal team will fight it tooth and nail, just like we would in India, for example. So approaches differ, and I think everybody has faced this situation there, but having a policy makes it easy for us to at least have that conversation.
Very helpful, very
So,
helpful. Thanks,
Sanjay,
Rishi. Yeah, Deepak, you wanted to say something? Yes.
just adding to what Rishi mentioned, and this is a common situation which we all of us face. Having a good matter and litigating on a good matter and then going back and saying that you got to settle it and you should settle it, that's the best outcome, because you may have a client or a customer who is an ongoing customer. You may have a great case against him, but you still don't want to pursue. So those sort of things really help when you have a policy saying that, look, your policy requires you to settle with a customer, not be in a litigation with a customer. And Kingshuk would know we did that in Saudi Arabia very recently on a matter last year. So classical examples of where we've settled even when you had a great case.
Yeah, no, I think absolutely. I'm sure the terms of settlement did favor you because you had the upper hand there. So I think that's the. But yeah, it's a wrong notion that if you have a good case, you must not settle. I think that doesn't help to prolong a dispute for anyone. So I think we'll come back to that. So I think the next question, I think, because Akhil, you mentioned that one size will not fit all, and you must have different approaches. So the next connected question is, when drawing up litigation policies, do they provide guidance as to the risk appetite of organizations and materiality thresholds, which dictates the approach of the company to a dispute or even pre-litigation strategy? What's your take on that? And maybe I would invite also Deepak Acharya to supplement Akhil on this. Two key facets: the risk appetite, the policy, does it dictate that? How does it dictate? And the thresholds as to a settlement or pre-litigation litigation. Yeah.
So one is, Prasanjit, as I see it, there are two aspects. One is a business dispute or a commercial dispute, and the second one is a regulatory dispute. Let's first talk about a commercial or a business dispute. So if you are defending your company in a say, for example, let's talk about airline manufacturer like us, with a vast supply chain, and we are talking to or we are litigating with a very big supplier of say somebody who is supplying parts and components to us which are very critical. So in that case, it is very important to keep all stakeholders together. And in that case, the general counsel may not be the ultimate deciding factor because it's a commercial or a business dispute. So while we will facilitate a dialogue with the counterparty or the supplier, it is very essential that we do not take everything on our own shoulders. In a sense, in terms of all the issues, while a legal counsel's office is to facilitate a dialogue, but it is very important that we should not let our business colleagues slip away, because they have to be constantly engaged in that commercial dispute and the commercial discussion. Because at any stage, because litigation process is a long process, which takes a lot of time, it exhausts a lot of energy. People think that the outcome of a litigation should be very quick, which is the other way around. So it is very important that you should have business partners constantly engaged in those discussions, so that at any point of time there may be a bright idea of resolving that particular dispute. So in terms of risk appetite, it will depend upon the stage of the litigation, what stage you are in, what are your stakes, how adverse or in a better position you are depending upon the facts of a commercial dispute. And then you have to take a call, whether I get a benefit, whether I lose a supplier, whether I should develop a supplier, do I have the opportunity to fight or litigate, continue to fight or litigate against a supplier which is a very critical supplier. So these kind of decisions are very important, which a general counsel alone cannot take. It becomes very critical that you engage your business teams so that that decision making is clear. The other part of the litigation, which I believe is the regulatory litigation, or when you are fighting against the regulators or government enforcement agencies, there perhaps a general counsel will have a better decision making power, because a general counsel office knows the regulator more than the business colleagues. So for example, in a regulatory raid or in a regulatory inspection or in a regulatory enforcement, business colleagues may want to come and tell you that let's resolve this issue. But a general counsel will have to balance it out, whether you have to take an adverse order on record or whether you have to fight it out. So in that case, you as a general counsel will have to have a decision or a more say in that particular matter, that no, we will rather spend more money on litigation than to take an adverse order which may have an adverse future on the similar issues that the company may face in future. So in both situations, we really have to balance out the risk appetite. A business or a commercial dispute, engage with your business colleagues, keep them constantly engaged on the issue so that you can take a quick decision. On a regulatory matter, I think it is more the buck stops with the GC. That's how I think.
Very good.
So,
I think that's Deepak. Yeah.
Let me touch upon, and I agree with what Akhil mentioned. I think the gist of what Akhil is saying is that depending upon the litigation, a business leader or a general counsel can be on the driver's seat. But let me touch upon slightly different aspect of litigation management, which is more and more prevalent nowadays. And sometimes we initiate it that way, sometimes we are forced to defend it that way, which is that more and more, as commercial litigations are taking more time to resolve, companies are trying to see how they can actually convert a commercial dispute to a criminal dispute. And therefore, they know that if the criminal disputes are initiated, there is much more chances of parties coming to the table to negotiate a settlement. And that aspect, as a corporate lawyer, one needs to be very careful about, one needs to be very mindful about, in terms of how do you handle a situation which is primarily a commercial dispute, but has been converted or is being attempt is being made to convert that into a criminal dispute. And there you have to put your foot down and defend it in a way which is protecting the company's reputation. And if you tend to then settle those kind of disputes because it has become from commercial to a criminal dispute, then more and more companies will start initiating that kind of a dispute against you. So, you may say that, okay, in one particular case, I will go ahead and settle it because it has become a criminal dispute against the director of the company, and I don't want to take a chance with the criminal dispute involving the director. Let me go and resolve this dispute. But then the flip side is that more and more people in future would try to pin you down in the same manner. So this is one area where I would want, corporate counsels and general counsels to really think through before actually settlement can be initiated, particularly where reputation is involved and it's a criminal litigation that is being initiated.
Yeah, no, absolutely. I think resonate with this point fully, and I will not reveal which side of the table I was, whether I kind of strategized to initiate a criminal or was in the receiving end. But because incarceration risk and threat poses much more headaches than just a civil suit which will go on forever. I think that issue is there which impacts your reputations, and therefore that aspect, how you strategize, should be documented. And of course, I mean, these policies are dynamic. One has to keep on evolving them from time to time. But this is a very critical aspect, that if there's a reputational angle aspect, it needs far more, focused attention, I would say. So that's a very interesting point. I think moving on to the next point, and this I will go to my partners Raj and Kingshuk here, because this really talks about alternate dispute resolution mechanisms, where they are champions in that field, like arbitration, conciliation, mediation. Now, should alternate dispute resolution, ADRs as it's known as, should they feature in a litigation policy, and should a policy favor arbitration over litigation, and in what circumstances? I mean, the common perception is arbitration the quicker in time span, and therefore, is it as simple as that? And therefore, should arbitration be always the preferred mode, or there are nuances to it? Raj and Kingshu.
So, thanks, Prasenjit. So I think, as Akhil started in the beginning when he said that this is not like one size fit all approach. So basically, you have to consider what the company is into, what is the business of the company, are what sectors they are in, because certain sectors tend to have high litigation risk, certain sectors don't have that much exposure to litigation that you feel. Therefore, they would like to have a mix of multiple alternate dispute resolutions in their policies, which can help them to get on with business if they have to, because generally the companies want to get on with business. They don't want to litigate and spend their time in court. Now, options that they do have and that the policy should keep flexibility to would be probably negotiations, mediations, conciliations, arbitrations, and the litigation. Now, today, negotiations and mediations and conciliations are becoming kind of a norm. Everybody wants to first ensure that there is a window to negotiate or mediate or go in for a conciliation to ensure that you don't end up getting into disputes. Of course, arbitration and litigations are always there. Now, would I call arbitration an alternate dispute mechanism, or will I call it another mode of dispute resolution? Because it's not just an alternate, it's another mode available completely differently and distinctly to resolve your dispute. So it's not an alternate to litigation, it is a separate mode altogether as well. I think what is important is there should be a requirement, there should be some provision in the policy to escalate if the matters are not getting resolved in a contract, that if matters are not getting resolved at a particular level, they're escalated to higher management level, and management to management discussions take place. We see a lot of matters getting resolved in that sense and that in that form. So it's important to have that. The other important point that we think is, uh, how do you use these tools, and at what point do you use these tools? It's not in some matters you may not want to start immediately by negotiating or mediating or negotiating. It may not work.
Raj, we have lost your audio.
Sorry.
Yeah,
You know,
now it's back.
Yeah, so at what point to use these strategies, because sometimes you may have situations where people are at each other's throats. There may be swords taken out already. People may not want to resolve it at that point in time. There's just too much uh, anxiety there. There's too much anger against each other. But so maybe you have to look at the right time to see at what point in time would you start going to mediation or a negotiation or other such policies to then bring parties to a discussion table. And that sometimes is far more effective than going at the first end and saying that let's negotiate. Many people don't want to do that, right? So that's something that we do. Yes, arbitration is probably post negotiation and mediation. I think arbitration is the most preferred way of resolving disputes in today's day and age, because we all know that courts are burdened with litigation, and courts just don't have time to give enough time to all the matters. It's taking time. Every matter is getting stuck in court right now. So arbitration is a better way to move ahead. It's comparatively quicker and faster. Of course, enforceability is also easy. It's not difficult enforcing awards. So I think arbitration is probably a preferred mode of dispute resolution today. Uh, of course, it also gives you such things like confidentiality, because the disputes between parties remain confidential. You have flexibility in the approach. You have the benefit of a expert tribunal who could probably a sector-specific tribunal, arbitrators or things like that, which could help you resolve your matters quickly. But I think with all of this, it's important that companies should know as to what is their eventual end object, what do they want to achieve, and then look at how to go about resolving it. Because otherwise, we keep fighting and we don't know what our end object is. Then it can create a lot of confusion within the organization.
Great. Okay, Kingshu, you want to supplement what Raj said? Yes.
Yeah, no, I think from a policy perspective, my view is, and this is my personal view, that the time has come to view arbitration very differently. And I'll tell you why this is the reason. And not just arbitration, any ADR mechanism. This is because litigation is really a result of compulsion, a necessity. You think about a litigation when a dispute arises. You get into a litigation when a dispute arises. But any ADR mechanism like arbitration, mediation, is something that you have to think about much, much before a dispute arises. And you have the ability to think about it much before a dispute arises. Because how many times have we heard the phrase that arbitration is a creature of contract? It's only if parties agree to resolve the dispute in a certain manner, adopting one of the ADR mechanisms, only then you can adopt one of the dispute resolution mechanisms. So therefore, the approach towards arbitration really will have to start at the contract drafting stage. It doesn't start at the stage when dispute arises. So from that perspective, yes, it is an element of litigation. When it comes to execution, yes, it is an element of litigation. But it's important to start thinking about ADR when you're drafting a contract. And I find the reality is, I know many of you here and most of you here perhaps don't fall in this category, but ADR mechanism and arbitration, the importance that it has in a contract, not too much emphasis or attention is put to it. That is the unfortunate reality, and that creates problems. That creates problems when the dispute starts. So from that perspective, I think it's good to have a policy in place, and that policy should contain the what, where, when, and how of arbitration. What do I mean? What I mean is, what are the disputes that you would refer to arbitration? When would you refer a dispute to arbitration? Do you want a mediation negotiation process to precede arbitration? That must form a part of your policy. Where would you commence your arbitration? When I say where, I mean what is the seat of arbitration. That will depend on your counterparty, nature of the contract. Let's not have a very rigid approach. We must have a variable, flexible approach to this. And finally, how is the arbitration to be conducted? Is it going to be an ad hoc arbitration? Is it going to be an institutional arbitration? What are the number of arbitrators that you're looking at? What are the kind of arbitrations you will bucket in when it comes to tribunal members, etc. So these are all aspects that ought to be looked at independently of a litigation policy. That's my limited point. We all know what the advantages are as far as arbitration is concerned, but arbitration really is relevant for a certain category of disputes. It's not relevant for all kinds of disputes, but for those category, some thought should be put in much before the dispute arises.
Perfect. I think that really establishes the fact ADRs are definitely, kind of should be looked at very favorably, but under certain circumstances, I think one should keep a flexible approach to look beyond ADRs also. And it's again horses for courses. What really is appropriate should be kept in mind. And that's, I think, a very important point, because no policy can be again cast in stone. I think that's really something we should always be mindful of. Well, thanks, Rajan Kingshuk, for those thoughts. I think let me go on to the next question. Now, this is very interesting, and for our audience member, I'm sure, because many of the general counsels who are joining this would have businesses. The companies will have business not only confined to Indian territory but across the globe, and therefore the natural question which will come to their mind is, look, does your approach to a dispute or a litigation change based on whether it is a domestic issue or is it an international issue? So if I may just pick brains of Rishi, you first, and maybe Deepak Chauhan, you can supplement Rishi on this.
No, thanks. So absolutely, I mean, each one of us and our audience are all experts in the Indian, or have experience with the Indian dispute resolution scenario, and Kingshuk already sort of summarized along with Raj. So, but I'll speak a little bit more on how the international disputes makes us look at things in a different light. So, if I may say broadly, common law jurisdiction where the dispute has arisen, or if the dispute is subject to a common law jurisprudence, would make all of us inherently a little bit more comfortable, because I mean, a lot of our basics are similar to the basics of a common law background. So Australia, UK, to an extent, United States as well. And I think for a lot of you, you have businesses in Africa as well as South Asia. So South Asia, Africa, a lot of them follow our laws similar to what we have. That's the easy answer, because inherently you are equipped to answer, or at least understand, the expert legal advice that you get in terms of what is to be done, what's not to be done. The trickier thing comes in is when you are faced with the dispute in a non-common law jurisdiction, and your policy, I mean, at least our policy simply just says we go by the expert legal advice on jurisdictions where we do not have legal expertise. So we obviously we have English solicitors, English lawyers sitting in London, and US qualified lawyers sitting in US. But if we do not have expertise in those jurisdictions, our policy would simply say take the advice. But that is where the fun begins, if I may say so, because not just us, our stakeholders, our management, our board, everybody then needs to be sensitized about the approach and how the approach differs from India. So, I mean, immediately you would get stuff like hold notices from the US attorneys or counsel. You will have to sensitize people about what discovery means and how what privilege means, and how that those rules operate in a different manner from what they would be used to in India. What not to say in writing, on emails about the dispute when we are talking about it. How to sort of move things to a more verbal communication. So those nicer, finer things apart, the more critical thing comes up is how do we resolve the dispute in the first place? Uh, is, is the quantum of damages that everybody has in his or her mind, whether we are claiming or whether the other party is claiming, is that quantum likely to be the final outcome in a different jurisdiction or not?
Right.
Is the first hurdle that we sort of encounter, and things then go on to become more interesting there. So just to sort of not to stretch this thing and then let Deepak give his perspective as well. It requires a lot of thinking. It requires a lot of expert advice. And I must say that very often our Indian counsels are in a position to provide at least the starting point that, hey, look, you are facing this dispute here. You don't have much experience, but at least keep these 3 or 4 points in mind, and then we'll help you in referring the matter or whatever, getting the proper expert legal advice.
Right. Right. Thanks, Rishi. Deepak. Yeah.
Yeah, so I'll take up exactly where Rishi's left it. So our policy requires us for any international matter to have an Indian counsel on board even before we have a overseas counsel, because that really helps us in selecting an overseas counsel. So typically we use our Indian counsels to help us even for the selection purposes of an overseas counsel. So exactly as what Rishi mentioned, that the stakes obviously are very high, and typically global reputations, because then let's say if you're doing a matter, you have a dispute, say in any of the overseas jurisdictions, they tend to get picked up by your clients all over the world. Once it's not a localized issue, then it's a larger issue. Let's say it's a customer issue. It kind of derives a lot of focus and attention, and gets a lot of focus and attention from the media, from other from many stakeholders. Then so it becomes very important how you conduct yourself. Going back again to the start of it, you need to have a very robust mechanism to resolve it. So as Kingshuk mentioned, get down to at the time of even drafting the clause. For example, we have business interests in Saudi Arabia, and from a jurisdiction perspective, what sort of clause you will have, or UAE for that matter. What sort of arbitration clause? How will you structure an arbitration clause? How will you actually arbitrate, if at all you wanted to do a arbitration? So you actually need to start at the contracting stage itself as to what would be your sort of thought process when you're looking at from an international perspective. Then again, as Rishi mentioned, the whole discovery process, very painful. We've had a couple of instances where we had to go through this, and it is very important to sensitize people internally that this is not going to be an easy process for you. The whole cost benefit analysis will have to take into account the kind of discovery which you will be encountered with if you ever were into a litigation, and you would look at the whole cost benefit will change tremendously if you were to look at the overall cost that you look at from the perspective of running a litigation end to end fully. Then of course there are normal triggers that one would have from a policy perspective of when do you go to the board, when do you kind of trigger the board, how do you kind of try and resolve. All in all, I think it's a more strenuous exercise whenever it comes to an international dispute, and you want to try and see that you don't sort of venture into that as much as possible, try to come out of it as quickly as possible. And as a rule, you want to trigger it only if you feel very confident and comfortable that you want to go forward with it. That's what I would say.
Right. Now again, those are, yeah, Deepak, please, yeah.
If I may add one point, which is very critical in my thinking, whenever you are looking at the international disputes, particularly jurisdictions where there are possibilities of class action being initiated. And when you have a class action litigation, it's a very different ball game altogether versus litigation with the individual parties. And we all know that jurisdictions like US, you have the ambulance chasers who would really go ahead and get all the plaintiffs and file a lawsuit. And one must keep in mind that countries such as US, Israel is another example, where initial plaint that is filed against the company is very bare bone. It doesn't give you a lot of information. And when you read that plaint, you will realize that it has given only very limited amount of information on the cause of action. And people with the common law understanding will tend to reject it by saying that there's nothing in that litigation, but it's actually a very misnomer. Most of the US litigations start by disclosing nothing to the defendants. And only during the trial proceedings more and more information will be given out. And if you have reached a stage where there is already a discovery initiated, that means you have already, in a way, you have already incurred 50 to 70% of the cost of litigation. Now, in for example, in US, it's not easy if you are already into a discovery process. The costs are humongous, and therefore one needs to think through either before you initiate a litigation or you defend a litigation, that at what stage you should start thinking about, settlement or likely settlement, and what are the odds that how much you will be asked to pay, and particularly if it's a class action and a jury trial, then you have a very, very tough decision at hand. So I agree with Deepak as well as Vishy. International litigation and litigation, particularly in markets where you have class action and jury trial, it's a very different ball game altogether, and it requires a very different understanding of how these jurisdictions operate and how the entire litigation ecosystem works.
Yeah, no, that's an incredibly pertinent point, Deepak. I'm glad you touched upon it. I think class actions, or I think US anyways is extremely, kind of a busy litigation market, so to speak. So I think your radar must be absolutely switched on fully as a general counsel here. So that's a very, very valuable interjection. If I can go to the next topic, is of course many of you would have companies which not only have one business segment but multiple business portfolios. Now, how does that impact your litigation policy? So essentially, do you have bespoke, customized litigation policy for each of those business segments, or do you have a holistic, overarching kind of a corporate litigation policy? So I think that is something I'm sure people would want to understand. And if I can request Deepak Acharya, you and maybe Raj, you can supplement Deepak on this topic, that would be helpful.
Prasenjit, it all depends upon the industry that you are in and the businesses that you are working in. For group of companies that we have in our group, we are very different and diverse companies in our group, and therefore, one size fit all doesn't really help us at all. Our policy has to be overarching policy or something. I wouldn't even say a policy. I would say it's a guidance that we issue. Leave each company to decide the litigation to be initiated or to be defended by themselves, because they know how they are in a position to defend it or to initiate a litigation. But of course, there are certain overarching principles that we do share broadly with the group companies, and therefore it guides them in terms of how do we look at the litigation, particularly in the markets that are outside of India. And then in mind that our 55% of our business is actually outside of India for the group. So certainly we do get a lot of issues which are not India specific outside of India as well. But I would say that there is no straight jacket formula that applies for sure. And one has to be flexible enough to devise a strategy that is right for that litigation. As you see, one thing which also is very critical, and I'll share this candidly with the participants here, See, most of the litigation in, and I would say this is applicable to all companies, most of the litigation actually starts with the ego disputes or ego issues that come up between the two individuals, right? And the way the higher up those individuals are in the organization, and the way their egos impact in a discussion or a negotiation or a day-to-day conversation will have a lot of bearing on the litigation. And one of the ways a litigation policy should figure out a way to filter out those egos and look at the real issues that are involved in potential dispute and a potential litigation. I've seen that if you have a mechanism to keep the ego issue aside and look at the issues in its totality, there is a much better way to decide on the litigation or a dispute. And that's the job of the general counsel. Business would come to you, charging to you, saying that we must file a lawsuit, we must do this. But you have to understand what is driving it. Is this a personal issue? Is this a individual issue? Is this an organization policy which is driving this? And therefore, GC is in the best position to understand the overall environment and take a call and filter out that noise from the system and work on the real issues that are involved in a litigation. So that's what I would say, that your policy therefore has to be flexible enough to take into account these kind of issues that every GC is bound to get, for sure.
Excellent. Raj, if you want to supplement, Deepak, yeah.
Yeah, I think I completely agree with Deepak on what he said. I think he took away my words from my mouth, because he said exactly what I was going to say. But I think there cannot be a straitjacket formula for these kind of issues, because every business, it depends upon the nature of business the companies are into. Like if a company has multiple lines of businesses, you can't have a same policy across. Of course, you may have an umbrella overarching guidelines, as Deepak rightly said, but for specific businesses, there may be a requirement to have flexibility for each one of them to look at it differently. Like for instance, if there is a dispute with government entities, then it's a different approach. Now, if it's a dispute between two corporates, it's a different approach. If there is a cross-border dispute, there is a different approach. Now, every business may have a different nuances within itself. So you have to be flexible to be able to cater to these kind of situations. Also, there may be some businesses within the organization which may be high risk litigation areas, like say for instance, regulatory, infrastructure, real estate. These could be high risk areas, but there may be others such as manufacturing and supply, and which may be resolved far more amicably. And that's possible that there is a different way to deal with those kind of commercial disputes. And of course, there has to be a separate mechanism for how to deal with criminal matters, because those can be the most important and strategic matters. How to deal with these criminal litigations that can be, as was rightly pointed out, many a time commercial disputes are given a criminal nature, and how to then deal with them and to ensure that the board is protected or the critical key members are protected is also very important. So while there should be a larger policy, but at the same time there should be flexibility available to general counsels and the companies to be able to maneuver themselves as and when required, and how to use each each alternate mode of dispute resolution effectively.
Right, Raj. So I'm mindful of the time, so maybe I will take few more questions to this panel and then take some audience questions before we go to the poll and some parting thoughts from our panel. I think the next question, I'm just curious to ask this. I think the role of external counsels, and at what stage should the in-house counsel team reach out to external counsels and retain them? And in relation to potential dispute, I can see King Sugar and Raj getting very excited with this question because they are the port of call. But if I may ask Akhil, I think to shed some light, and maybe Deepak Chauhan, if you can also supplement Akhil on this one. Very critical point, important point. Should you go too quickly, or is it too late? What juncture you should go in? When to go, Akhil? You can begin with.
So that's a very valid question. And as businesses become more complex, and as businesses are developing in-house teams, I think there has to be a very great coordination between the in-house team and an external counsel team. But the reality is that as businesses are expanding their in-house team, I think the day-to-day work for a general counsel is growing multifold. So if you were to look at how do we do our work on a day-to-day basis and how much do we outsource, I think that pie is increasingly going in favor of an in-house counsel office. So on a day-to-day basis, I would say that about more than 85 to 90% work, excluding litigation, because litigation is something which you cannot do on your own, and litigation has to go to an external counsel. But other than that, I think pretty much the entire legal work is being done by the in-house team only. But that does not mean that the support from the external counsels is going to get minimized. I think it's going to get expanded because businesses are getting more complex. The business environment are getting more complex. There are more regulators. There is more competition. Business colleagues need more creative ideas. The role of a GC today is not only to provide a legal advice, but to support on business decision and be a strategic advisor. So strategy is very, very important as a part of a general counsel's office. So if that is so, and if the things that a GC needs to do is changing every day, I think for complex work, there will definitely be a lot of external counsel. And I think what needs to change is that the landscape of legal advice is getting transformed. So for example, what we talk about chat GPTs, artificial intelligence, as things become more complex, I think that is where external counsels really have to speed up. They really have to devote a lot of time, energy to understand the various business sectors. So I think it is not automatic that somebody who is a very experienced litigator or somebody who's a very experienced corporate lawyer automatically becomes an advisor to an aviation company. I think there has to be a lot of work which an external counsel firm needs to do to develop that capability. For example, in our industry, what is it that the space travel is doing? What is it that the rocket launching means? Private sector is coming into launching rockets. What is it that more sustainable fuel? How do you make businesses more sustainable? I think these are the type of issues which an external counsel firm needs to develop knowledge in a higher trajectory than an in-house counsel office. So if you are on a trajectory which is higher than the in-house counsel office, then that is the value that you bring on table, and that is something which goes in future will have to be something which you need to demonstrate, and which will be very helpful as a partnership between an in-house office and an external counsel office.
Right.
So, Prasenjit, everyone, I think, first of all, understanding that, because let's say in our case, we have multiple businesses, it's very important that you have, your legal counsels involved in a particular business, and you get them, there for not just for one litigation, continuously. It's a journey so that they understand your business very well. So I would always recommend that you have a particular set of counsels dedicated to a particular business if you're structuring it that way, and don't change them too much. Keep the same counsels with you who understand your business, who know the people, who can, it's very easy for an MD or a CFO also to pick up the phone, speak to them in case of an emergency. So one, always follow that strategy. Don't change your counsel too much. Don't, have new counsels. So follow a practice of how you do that. Then again, a lot of it comes from case law precedents in India, of course. I'm saying when you look at from a case law precedent, the law is evolving. And that is where in-house counsels may find it very difficult to be in touch with all the time. Okay. And therefore, when you reach a stage in any sort of potential litigation where you're going to be in a stage where you're going to be, casting the die and, going to take a position, just before you do that, you please ensure that you've bounced off with your external counsels, because that's the typical stage. Let's say the last communication which will trigger a litigation. I mean, that's the time when you should definitely, bounce off with your external counsels, because that's when you take a position, I would say. Okay. And lastly, I would not even stop at, just going to the law firms for larger and more critical issues. I would say take it up right up to the counsel. Get a first-hand feel of how the courts will view it. Okay, go to that level. If the issue is quite serious and you want to, take it up, might as well take an opinion at the right time from the counsel itself, and then take it forward.
Excellent. Yeah, I fully. Yeah.
Can I
Deepak.
come on one point? Sorry. So I'll be very brief. I know we are running out of time, but 2 points I want to mention here, which are critical in my view. I think one critical aspect that all GCs should look at is the legal privilege. And we all know if it's a litigation that involves competition law, none of us have privilege under the competition law. And it is utmost important that we should involve outside counsel upfront and very, very quickly before a lot of information becomes not protected by legal privilege. So I think one thing, and even in disputes and litigation in US, in other markets, correspondence that you have with the lawyers and law firm is legally privileged. And one needs to keep in mind early involvement of outside counsel always helps you protect that privilege, legal privilege. So that's one key critical piece we should remember. The second aspect, I think litigations, I would slice it into two different parts. And one is litigation that is strategic in nature and litigation that are technical in nature. And for strategic litigation, it is always important that you work with the outside counsels early on. And I think Deepak was rightly mentioning that don't change your counsels, don't change your law firms, and make sure that you work with the law firms that is, that knows your business very well, that understands your business very well. So in case of a strategic litigation, outside law firms deal with those kind of litigations day in and day out. It is just one litigation for me, but the law firms handles those litigations maybe for 20 other clients, and therefore they get information and they get insights which are far more useful for me as a client. So I would say that, for strategic litigations, reach out to your trusted law firm at the earliest. That will save you a lot of cost in future. It's not, it's going to be very, very important in winning and losing a case if you involve the right law firm and the right partner in the law firm who understands you, who understands your business very early on.
Excellent. So that's a good introduction, Deepak. I think with that, I think given the compulsions of time, I think let me go to the audience Q&A. I've got a fair number of questions coming in. I'm just trying to filter and sift through. I think one interesting question which has come in, I think very topical also, is how does technology impact and help you in litigation management? So if I can again maybe request here, Akhil, if you can, if you know, maybe Akhil and Rishi can supplement. Maybe Deepak Acharya, you can also go with this. Role of technology in litigation management.
So thank you. Yes, technology. I mean, this was already mentioned now, but see, again, I mean, we're all aware about how digitization of records document management systems, cloud-based availability of documents and information. They have. I mean, these tools and the easy access and high bandwidth availability have really changed the way not just litigation but any sort of legal work was done or was implemented. Uh, what 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 I would say is that the case management tools. I mean, not just about high-end litigation, which are few and far between, but litigation, like for example, proceedings that you would have, regulatory proceedings or whatever your industry-specific proceedings. It's very important to be remain on top of it, and very often that role is played by the in-house team, where the external counsel probably most likely being a local counsel practicing in a local court. So case management tools and softwares which are increasingly getting advanced today help enormously. Um, of course, I mean, I recently was given the benefit of a presentation by artificial intelligence driven advanced analytics to review your existing sort of case papers, documents, and those sorts of things. It's an evolving picture, but I was terribly excited. But again, I would say that that is something which the internal legal teams, I mean, neither do we have expertise nor the budget to do something on our own with integrating these evolving tools to help assist not just in our litigation management, but have an overall view on the legal work that we're doing. And we would look at external counsels and other alternate legal service providers, as they call themselves in the UK, to provide tools that will help us maintaining an edge and increasing efficiencies in our day-to-day work.
Right. Anybody wants to supplement that, or should we?
Yeah, so I would say that it is absolutely critical that on the justice delivery system, technology should be embraced at the earliest, because India is definitely way down in terms of providing speedy justice. So while corporates and others will embrace technology, I don't see a problem. But the problem that I see is at the criminal courts, at the district level, civil courts at the district level, high courts, appellate courts. We have to have speedy justice in this country. And unless we ensure that, it is not going to work. Our dreams of becoming so many trillion economy will only be further dampened by a system where you don't get a speedy justice. So that is something where we need a lot of focus on technology advancement, whether artificial intelligence or whatever it may call. But somebody who's filing a litigation needs to have a speedy justice. That is the need of the hour.
So,
Right.
Prasenjit, let me quickly add a couple of points here, particularly in the international context. Internationally, whether we know or we don't know, a lot of technology is already being used by the law firms already. Law firms are using technology in terms of giving you a service. You may not know that they are using technology to provide you that service, but there is a lot of technology that is being used. Best of the law firms have invested in huge technologies, and they are going. So, for example, in US, there's a company that provides you very much prediction on how much are your chances of success if this case were to go before A judge or B judge. To that granular level, the technology is helping you to find out if this case goes before this court, in that court, what are the chances of your success of the case. And that is all done based on the predictive tools that there are based on the past judgments that those judges have given, and so on and so forth. So technology is very, very critical, and unfortunately, lawyers, and particularly in India, lawyers are very slow to adopt technology. And when we look at video conference in Supreme Court, we think that it's a technology. we feel very happy about it, but oh, what a technology that we have. I mean, that's the basic technology that was already in use in US 30 years ago. So that's not the technology that we should be looking at. The real technology that is coming in legal sector is being used in patent infringement cases, is used in trademark related matters, where you assimilate global data, you assimilate global information, and then come give your prediction on how your patent application, there's a chance, for example, of getting approved or not approved. So there's a lot of work that is going on right now in the legal field. uh, you know in India, of course, we are still at the very beginning, but I think all of us lawyers in GC should embrace technology for sure.
Sure, Deepak. I hope people who are listening in will follow suit and embrace technology and kind of change the perception. But you rightly said lawyers are slow in adopting technology. Hopefully they will expedite that. We're completely out of time, but I will ask one last question just because it's an interesting one and it's from law firm partners perspective. Rajan Kingshu, the question is, do you see any merit and advantage in companies having corporate litigation policies? A very fundamental question, rudimentary question. Of course, they have clarified it is. In your view, honest view, candid view, do you think there is merit, or is it really something nice to have and not a must have? Very quickly, if you can spend a minute each before I go to the tail end of the session.
Raj, why don't you go?
So my view is that yes, it must have. It is good to have that a litigation policy. It also gives clarity to the team within the organization as to what are the next steps that they're supposed to take. It also knows that what are the go areas and what are no go areas for any organization. And if your lawyer team also knows that this is basically our litigation policy, while the lawyers also at the time of recommending will understand that this is what they will do and this is what they will not probably do. So that helps to understand, and I think it really helps it. It also gives a clarity on which are the kind of matters that they want to escalate, whether they are policy related matters which they will escalate, or whether are critical matters or criminal matters that they will escalate, and what happens to the commercial matters and the cross-border matters and how do they want to deal with it. So these policies give this kind of a guideline, which is kind of a good idea for anybody to have. I think it's a good thing to have.
Oh, likewise, PC, I'll make it very, very quick. I think why it's important is because as lawyers, we want quick instructions. We want smooth, seamless flow of instructions. That's one of our wish list. And I think the personnel handling the litigation, if they're empowered with a litigation policy, I think empowerment is the key. You must empower individuals in the firm who are handling litigations to drive a litigation in a certain manner without being worried about the consequences. I'm not saying that you have a free go at the litigation, but empowerment is necessary. And that empowerment does help us as external counsel because it makes our job much easier, because we receive instructions which are not caveated and qualified. That really does help. So to that limited extent, I think empowerment is very key. The other thing that I want to quickly point out is flexibility. I think the common theme of this discussion has been have a litigation policy which is flexible, not rigid, and that, to my mind, is also key. If you want a solution-driven approach, if you want to achieve your objective quickly and resolve the matter, it's important to have a flexible approach, because litigation is a very creative exercise, and creativity can't thrive in the backdrop of rigidity.
Right, absolutely. I think that's a very good way to kind of inch towards the end now. I think, and also I think because a litigation policy, while being drafted, I think, of course, the in-house counsels who have the great understanding of business will be primed to take the lead, but I think a bit of inputs from law firm partners will also be helpful because they can share their perspective, and it's a holistic kind of a policy then which can be framed. Normally we do this key takeaways, but I think because we are short on time, what I will do is we will send you the webinar summary, which will have the key points. I've jotted them down as my fellow panelists were speaking, so I will send that. If we can go to the poll slide, we'll spend 30 seconds on the poll before we do the vote of thanks. Prajay, can you go to the poll slide, please? Great. So I think before closing, I will like to request each of you to respond to the poll slide, which is there on the screen right now, to provide your feedback for today's webinar. We take this obviously very seriously because we get to know if it's good, not good, and we can continually strive towards excellence. So just 30 seconds, and we will then go to the conclusion. There you go. So I think audience Q&A is done. I think, Mitesh, we can go to the conclusion slide now. So I think thanks to everyone who have participated, in the poll, and I think I would like to extend a wholehearted thanks to all our esteemed panelists: Akhil, Deepak Acharya, Deepak Chauhan, Rishi, King Shukraj, who were outstanding, and also to our audience for their attention and time. I really do hope honestly that you found the webinar very useful and gave you some food for thought, and was a worthwhile investment of your valuable time. We certainly, as always, enjoyed bringing it to you. After this webinar, we will send you the recording, the summary, those who could not tune in today, for your benefit. You will also receive separately a feedback form, and please spend a minute to share your thoughts, criticism, compliments, and any comments. If you're interested in in-house training or any other matters arising from this particular webinar, please don't hesitate to reach out to us. Our contact information is on the slides at the back end. The slide, Prajay, if you can project the contact information there. So I think thank you again for your attendance today, and we look forward to being with you again at the in-house counsel forum. Until then, stay safe, take care, and have a very good day. Thank you very much.
Thank you. Thank you.
Thank you.
Thank you.
Thank you all. Bye bye.